Hi, my name's Adam Pipe, and this is the first of what I hope to be a regular immigration case law update on video, which I'll post to my YouTube channel. Today I want to look at one case, and that's a case called Jowanski Muwonge, and it's a recent upper tribunal judicial review decision from the President. I don't know if you're like me, over the last few months to a year I've been having problems with cases consenting with the Secretary of State serving a consent order with the acknowledgement of service. Now, they'll agree to reconsider the application, but what they do in respect of costs varies from case to case. In some cases, they agree to pay our costs following Barter and Emin Croydon principles. In other cases, they argue no order for costs, and still other cases, they ask for their own costs, even though they're agreeing that their decision was unlawful. Now, this case concerns that last scenario. Mr. Muwonge was an applicant in person for judicial review at the upper tribunal in a very colourful determination, quoting Hamlet and describing them as David and Goliath. Looks at his case, and what happened is he challenged an unappealable decision, and the Secretary of State, in a very late acknowledgement of service, agreed to reconsider the case within 3 months' time. But the Secretary of State asked for their costs in the sum of £90. Eventually this was brought in for an oral permission hearing, and by that time the Secretary of State was actually asking for the case to be dismissed and had upped their cost claim to £610. Well, the President couldn't believe this, and he said there was no justification for it. So what he did was find that he approved the consent order. He amended it to change the reconsideration period from 3 months to 4 weeks. And that's a helpful tip actually for the future, maybe to challenge the period the Secretary of State is putting forward as the basis of consent for reconsideration. And he also made no order for costs in the circumstances. He did say if the applicant had been represented, he would have had no hesitation in awarding costs against the Secretary of State, possibly on an indemnity basis. The upper tribunal gives some guidance then on dealing with consent orders. They say that when a consent order is embodied within the acknowledgement of service, consent should be tried to be reached within 3 weeks. Because I don't know if you like me, sometimes we've had decisions from the upper tribunal on permission while we've still been resolving costs. And what he says is try and resolve it within 3 weeks of the acknowledgement of service. If you can't, within 4 weeks of the acknowledgement of service, provide written explanations and written submissions to the court. He encourages parties to communicate with the court by email, and also gives some shorter timescales when the case is listed. I've noted that the President recently has been given some really sort of procedural directions in judicial review cases. Another case is Bilal Mahmood, which is an important case on the continuing duty to reassess, and I'd encourage you to read these decisions. But this case is an important case worth looking at on the issue of costs and consent orders.